Joining us now on the line is Hans von Spakovsky. He's the co-author of the new book, Obama's Enforcer, and a senior fellow at the Heritage Foundation. We wanted to bring you in and talk about these two really huge decisions from the Supreme Court yesterday. I'd like to start with the one that has to do with recess appointments and the Supreme Court voting unanimously to tell the president, that you acted unconstitutionally by appointing members to the National Labor Relations Board and a recess appointment when essentially the Senate was not in recess.
Yeah, that case, it was a real slap in the face to the president. And by the way, if Eric Holder was the manager of a Major League Baseball team, he'd be fired for his losing streak before the court. They basically lost 3 cases before the court this week, all 9-0.
Yeah, do you think that, here's my theory. I think the Supreme Court is sending a message, and it's a message that should embolden Speaker of the House John Boehner, who is said to be, about to pursue a lawsuit against the president because he continually exceeds his presidential authority. Well, yeah, that may give them incentive, but I have to tell you, what the House really should be doing if they're unhappy with the president is using their real constitutional power, which is the power of the purse, and they really haven't done a good job of that.
Well, now, Hans von Spakovsky, let's talk about these recess appointments, because you were a recess appointment, weren't you, for the Federal Election Commission from George W. Bush? And a lot of people looked at that as saying, well, a lot of Senate Democrats thought that you weren't appropriate for the Federal Elections Commission because you have such, in my opinion, appropriate critical analysis of some of our election laws. So instead of going through the approval process or the committee process, George Bush just appointed you during recess. Why was that okay?
Because no one is arguing that the president doesn't have a recess power. Of course he does. But in my case, and the Democrats, by the way, who were recess appointed with me, the president waited until the Senate said, we are in recess.
In
this
That's a
case,
quaint notion.
Yeah, here the Senate said we are not in recess, and yet the president said, oh, no, in my opinion, you are in recess, and therefore I'm going to appoint these guys.
And so what the Supreme Court said yesterday essentially is the Senate gets to decide when it's in recess, not the President of the United States.
That's it. And also the court said, and this is based on historical practice going back almost 200 years, that they were very doubtful that any break by the Senate of less than 10 days could even be considered a recess.
Let's turn to the buffer zone law that also got struck down, the Massachusetts abortion clinic buffer zone law. I saw mixed analysis of this, Hans von Spakovsky, because a lot of people pointed back to the 2000 Hill versus Colorado case as still being intact, and that was the one that first enshrined the idea of a buffer zone. So why is this Massachusetts case somewhat different?
Well, it's different because what happened here is Massachusetts passed a law which said that you couldn't knowingly stand on a public way or sidewalk within 35 feet of the entrance to an abortion clinic. So it's not just that you were somehow endangering the safety of people going in, which is the way most of these laws work. If you're engaging in intimidation or physical threats. I mean, this one, if you're walking down a sidewalk and you're walking too slow, you would be committing a crime in Massachusetts. So this was a pretty extreme law. And while it was a 9-0 decision, the conservative judges would have, some of them would have gone even further, Scalia and Alito, in saying that this law was clearly aimed at and intended to stop pro-life activists, whereas the majority, led by Roberts, said, well, we're going to give the benefit of the doubt to the state legislature, and we don't think that's what they were trying to do.
Well, but in one sense, what they have said is you have to be close enough for there to actually be speech.
Yeah.
And that could be applied in a lot of different applications, it seems to me. For example, when you have protests in the nation's capital, and they put them 5 blocks away. I mean, it seems like you could make a pretty compelling case that, well, the Supreme Court has ruled that I need to be close enough where the speech can be heard.
Well, maybe, but I don't think so. What the court said was, look, this law just wasn't narrowly tailored enough. They could still protect the safety of people going into and out of clinics. they did not overturn what the courts have always said, which is that you can have reasonable restrictions on time, place, and manner, but here that it just wasn't a reasonable restriction like that.
So should this be seen as a victory for pro-life groups, as I saw them stating yesterday? Because it sounds to me like the law can be rewritten to be a little more focused and a little narrower, and it would pass constitutional muster.
No, it is a victory. It's a narrow victory. It's not as broad as folks would have liked, but it's still a very big victory. Again, particularly because, look, it was a 9-0 decision. So even the strongest supporters of abortion rights on the court, like Ginsburg and Kagan and Sotomayor, they still voted against Eric Holder and his Justice Department when they argued the case.
Yeah.
You know, in your new book, Obama's Enforcer, you write a lot about Eric Holder and his unwillingness to enforce the laws, or in some case, do as the president suggests and ignore laws. And the case in point that just is so dramatic right now is that the president instructed Eric Holder not to enforce immigration laws. And then the end result of that has been the disaster we're seeing on the border now. I mean, can you connect those two? I mean, to me, it seems very clear. The president tells the attorney general, we're not going to enforce immigration laws, and down in South America they read this and they say, hey, let's take advantage of this. If you get to America, you're going to be okay. Is there a connection between these two?
Oh, it is direct cause and effect. And in fact, the current crisis, particularly with all these children coming across, there was a scathing judicial opinion released back in December by a great federal judge down in Texas over a human trafficking case involving a young child who was caught at the border. And in that opinion, the judge basically says that the administration isn't enforcing border security. They are encouraging kids to be trafficked across the border. And you read that opinion from 6 months ago, and it's like foretelling exactly what we've got happening today.
Our guest is Hans von Spakovsky, and really fast, your book, as Brian just mentioned, Obama's Enforcer, you wrote that alongside of John Fund. You know Holder pretty well here. Yesterday, right here on Mornings on the Mall, Lanny Davis, Clinton advisor, defender of the Democrats and the Obama administration, said, yes, it is time for an independent counsel on this IRS scandal. And yet at the same time yesterday, the president doubled down on his phony scandals talking point. What's it going to take for a real investigation of this IRS thing, or is it really only in the hands of the House Republicans?
It's really only in the hands of the House Republicans. Eric Holder is not going to allow any kind of real investigation to go on that could in any way embarrass the president, and that's very clear because he has said before he considers himself part of the president's political team. He is the Attorney General, a very distant second, even a third, when it comes to that.
Yeah, and our nation's being shortchanged because of it.
Absolutely.
Yes, we are.
We used to have an Attorney General of the United States, but we don't have that anymore. Listen, Hans, thank you so much for joining us. Greatly appreciated.